Ladies and gentlemen, welcome to the People's Law School. I want you to know we bring the best lawyers in America here. Our next speaker is just one of those folks, and Joan-Marie Sullivan has been practicing law here about 25 years. I know that she looks like she's about 14, but believe me, she's been at it a long, long time, and she's a good one. The reason I say this is because she has always been in the pursuit of excellence. When she graduated from the University of Alabama, Phi Beta Kappa, and as a presidential scholar, she was one of those that the law schools, the big law firms in America come down and cherry pick the most brilliant people in the class, and a Kentucky firm, Lexington, Kentucky firm, got her, so she went up there for a few years and practiced law. But Mama called, she returned to Huntsville and practiced law with the big defense firm here, Lanier and Ford, for several years. And she was a trial lawyer and defended many products liability cases and all these other heavy-duty cases because she's brilliant, she's smart, and she's, as you'll see, well-spoken. But Joan-Marie has always been in the pursuit of excellence, and over the last 17 years, she has read every appellate decision of the Supreme Court of Alabama, of the Court of Appeals, and the Court of Criminal Appeals. It is an incredible task that she's done. She's produced the Alabama Law Weekly, which means she has literally read everything written by the appellate courts of Alabama in the last 17 years. I don't know of anybody else that's done it. In fact, I would say nobody else has done it. She knows. In fact, what I know, because I'm so old, is that I see the judges and the justices of our court system call her and say, Joan-Marie, isn't there a line of cases that says this, or isn't there a law that says that? They rely on her. I know the local trial judges do, and the appellate judges do as well. And that's quite an honor, and it's all right here, and she knows it. It's irreplaceable, and she's so far ahead of everybody else. I tell you, she is absolutely an expert in her field. She knows everything. She has specialized. When she left the big firm, she went out on her own, and she's been on Southside Square for a good while. She's specializing in divorce and such, and has done an extraordinary job. I know any time I have a divorce case, I always consult her, and I'll just say, just tell me what you think. Tell me what the judge will do. And she said, well, I can't tell you that. Tell me what the judge ought to do. And she gives me the quick answers, and I love her. And tonight it's my privilege to present to you Joan-Marie Sullivan. Thank you, Joan-Marie.
Thank you. Good evening. Alan, thank you for the kind introduction. I have always maintained that I know everything, and now there's confirmation, so I appreciate it. As Alan told you, I started out my career 25 years ago, working with mainly insurance defense firms. I dealt with insurance adjusters and corporate clients, and I swore that I would never touch a divorce case. They were just messy. I thought that divorce lawyers were the bottom feeders of all the legal profession. And I thought, how in the world do they make a living doing that? Then I had to get a divorce. And suddenly, that divorce lawyer that was representing me, she was a hero in my book. It was a crazy time, it was confusing, and I learned to respect those people that handle these matters. I can tell you that I firmly believe that there is no area of law that impacts more people than family law. I think if I were to ask you to raise your hands right now, that most of you would tell me that you are either divorced or the child of a divorce, or that you've had to help a friend or a family member get through a divorce. It's just staggering the numbers that we see each day in the divorce courts in Madison County and across the state. So, for the last 19 years of my practice, I deal almost exclusively with family law. I see people at the very lowest points in their life. My clients tell me that it would be easier, in some cases, to get through the death of a loved one than get through a divorce. Because arguably, death is generally not voluntary, and divorce usually is. Our job as divorce attorneys are to shepherd our clients through these difficult times, and I take that job seriously, as do most of my colleagues. And I'm proud of the role that we play. But our job gets a little complicated because everybody is an expert on divorce. You've heard of shade tree mechanics. Well, we have shade tree divorce attorneys. I think there is a divorce attorney in every coffee shop in Madison County, Alabama, and they are dispensing their advice every day. So when my clients come in to see me, they already know everything. I don't sometimes even know why they bother to hire me, because they know that their cousin Sally, well, she was in the divorce and she got this much money from the judge, and their brother, well, you know, he had custody and that's how it worked. But it's important to remember that especially in divorce cases, there isn't any general rule of thumb. Every case is different. Every family situation is different. We have 7 different judges here in Madison County who hear divorces, and they all see things differently. Unfortunately, most of them don't always see things my way, which can be problematic. There is no federal law or any kind of constitutional law that really governs divorces as there are in other areas. Divorce law is a state-by-state practice. So while you may have a relative in New Jersey that tells you this is how it happened, New Jersey law doesn't apply here. We have our own set of common law cases and statutes that have to govern. So when you hear about other people's states, it really doesn't matter. There's no general law that applies other than what our courts in Montgomery are telling us. To show you how far-reaching the effects of divorce are, I went online and I looked at some statistics, and even I was surprised by the numbers. Nationwide, someone who gets married for the first time, in 41% of the cases, will be divorced. Second-time marriages, 60% end in divorce. And if you are brave enough to try it the third time, 73% of those folks get divorced. The average first marriage only lasts 8 years. According to a study that I looked at, the top 5 reasons that folks give for divorcing are lack of communication, infidelity, financial problems, emotional or physical abuse, and just sheer lack of interest. Last year in our legislature, there was one of our legislators who proposed having a covenant marriage, which meant that you couldn't get divorced until you went through a counseling program. That didn't pass. I don't think it's probably likely to pass, but sometimes I don't think it would be such a bad idea. I don't think it'll be any surprise that the United States leads the country in divorces. What is surprising, however, is that our state, although it is in the Bible Belt, ranks number 4 in the nation in divorces. Last year in Alabama, there averaged 111 marriages that were performed each day. And each day, 56.3 people got divorced. Divorce affects all ages. Last year in Alabama, the oldest male was 95 years old when he got divorced, and the oldest female was 94. And at that point, I just say, why bother? If you've made it that far, just stick with it. But the largest category of divorces in Alabama last year fell among 30 to 34-year-olds. That seemed to be when people had changes in their lives, and I see that. That's when people kind of make decisions about children and sometimes make decisions that they shouldn't have had children. But the longest marriage last year in our state lasted 57 years. Anybody want to guess the shortest? 24 days. In Madison County alone last year, there was 1,145 divorces granted, and that was just in 1 year, folks. Now, I told you when my clients come in, they have lots of preconceived ideas about how their divorce should be handled and what the law should apply. And frankly, most of them are wrong. So what I have done for you tonight is to put together sort of my top list of misconceptions or mistakes about divorce. These are those questions that my clients come in and ask me, and I think if I just had a dime for every time they ask me that, I could retire right now. They get asked that often. So I'm going to go through these with you and see how much you all know about divorce, and hopefully you'll know more when I finish. The first divorce myth that I hear is that you don't have to have a reason to get a divorce in the state of Alabama. And technically, that's not true. Alabama still recognizes certain grounds for divorce, or reasons that you have to get divorce. There's actually 12 of those grounds. I'm not going to go through all of them. But here's the one that I hear most often, and it's abandonment. My client will come in and say, well, my husband said he needed some space, and so he went to go stay with his folks while we cooled off, and he has abandoned me, and I want to divorce him. That's not abandonment. Or on the flip side, I'll have clients say, well, we need some space, and we're fighting all the time, but if I leave, my wife will get me for abandonment, so I am not leaving that house and giving us some space. Well, that's not abandonment either. An abandonment under Alabama law is a final departure from a household without a reason and without an intent to return. And it has to be for a year. It's not just a cooling off period, it's for an entire year. If your spouse consents to you leaving, or if your spouse and you agree that he or she needs to leave, then it's not abandonment. Consent stops the abandonment process. In 25 years of practicing law, I have yet to see a divorce granted on the grounds of abandonment. And the statistics from Alabama bear that out. Last year, there were, in the state of Alabama, a total of 17,193 divorces. Only 32 divorces in the entire state were granted on the grounds of abandonment. You just don't see it. One of the hot topics in my practice is adultery. I get paid to hear that stuff, folks, and frankly, sometimes it's interesting. But in order for you to prove adultery, you have to have a whole lot more than mere suspicion. In fact, sometimes even having the admission of your spouse that he or she is cheating on you isn't enough. You have to have corroborating evidence, which is often hard to find unless you have a really highly sophisticated camera in the bedroom. But in divorce law, in the last 10 years or so, our favorite friend has now become Facebook. Folks, I don't know why you people put all that stuff out there, but it is a divorce lawyer's dream. I can't tell you. In fact, it's gotten so bad that when I bring a client in, part of my contract is that they have to close their Facebook account because people just can't stop getting on there and posting their personal business. And I can't tell you how many times I've been in court and I've been able to lay a Facebook post out there and say, excuse me, Mr. Witness, did you say this? Or is this a picture of you and your girlfriend? Well, what are you doing? You know, and those kind of things. So it's really changed the way that we've practiced law in the last decade or so, and it's made it a whole lot more fun. Last year, of those 17,000 divorces that I just referenced, there were only 116 granted based on adultery. Now, you and I have to figure there's a whole lot more cheating going on than that. But that just shows you how seldom it is that really people have the concrete evidence or that the court is inclined to put that as the ground for adultery. We just don't see it. It's also hard to prove adultery because some of you may not be aware that adultery is a crime in the state of Alabama. It is still on our books. Now, it's a misdemeanor. I think some of us could argue it should be something more. It's held here in the city courts or in the district courts of Alabama. It's not a felony. But we get a ton of calls saying that, hey, my spouse is cheating on me and I want to put him in jail. That doesn't happen. I have not, in 25 years, ever seen a case of adultery actually prosecuted by our courts. I think they have better things to do, or at least things that are a little less complicated. But technically, it is a crime. Because it is a crime, if I ask a client or an opposing party on the stand about adulterous conduct, they can claim their Fifth Amendment right against self-incrimination. They don't have to tell me. Now, because it's a misdemeanor, you can only go back a year. And so if they have cheated on my client more than a year, they have to tell me. But it's hard to get that information because often we hear, I assert my Fifth Amendment privilege against self-incrimination when you ask that really difficult question. So we don't see a lot of adultery-based divorces. Part of the adultery that I hear, and one of the questions that people ask me all the time is, what about alienation of affection? My husband is cheating on me and I want that skanky hoe to pay. And I want to take her to court, and I want her house, and I want her car, and he probably bought her that car, and I really want that. In Alabama, we don't recognize the right of alienation of affection. In fact, only 7 states in the whole United States recognize it. We are not one of those. You'll hear, I think I watched a Lifetime movie, and yes, I will confess, I watched Lifetime. Some woman had a $1 million verdict in North Carolina against her husband's paramour, and I don't know if she ever collected it, but I bet it sure did feel good when that jury came back and told her that, because she felt like her whole world had been wrecked by this woman. But we don't have that in Alabama, although I get lots of calls asking me about it. I sort of wish our legislature would go ahead and do it. It would just increase my client base. Another ground for a divorce in Alabama is insanity. Now, I can tell you, most folks going through a divorce, they're crazy. But in order to get a divorce based on insanity, you have to really prove insanity. That means that you're in a mental institution for more than 5 years and a doctor says that it's just not temporary like it is for most of us who would go through a divorce. Drinking and drugs are grounds for divorce, violence, imprisonment. But by far the big daddy of all divorce grounds is incompatibility of temperament. And that goes hand in hand with an irretrievable breakdown of marriage. They're sort of synonymous in the divorce world. Now, interestingly, these have only been around since 1971. If you wanted a divorce before 1971, you had to show some of those other grounds. You had to show the really meaty ones of abuse or adultery or abandonment. Incompatibility of temperament is sort of like our no-fault ground. It just means y'all don't get along. You and your husband have different likes, you have different dislikes. You just don't see eye to eye, and it's the fallback. And in fact, last year, 98% of all those divorces that I told you about in Alabama, those 17,000 divorces, 98% of them were granted on the grounds of incompatibility of temperament. The second myth that I hear is that Alabama does not recognize common law marriage. Most people, when they get married, they go to the justice of the peace or they walk down the aisle and there's a preacher at the end, they have a marriage license, and that's how most people are married. But Alabama is one of a few states that recognizes common law marriage. But there's certain elements of a common law marriage that we have to prove. Now, a couple of years ago, I represented this man, and he worked on a pig farm. And he looked like he worked on a pig farm. And he often smelled like he worked on a pig farm. But this man went to Tunica on one of his rare days off, and he won $300,000. And in fact, had one of those big checks, you know, that shows his name on it. And when he got that $300,000, well, his girlfriend suddenly thought she shouldn't be his girlfriend anymore, but she thought she should be his missus. And she pulled out a greeting card, and he had given it to her, and he said on the greeting card, you know, happy birthday to my wife. And she thought that was strong evidence that she was really married to my pig farmer. But my client confessed to me that actually he had just picked up the card and hadn't really read it, so he didn't mean to say to his wife. He just was lazy in picking out a birthday card. In Alabama, in order to be common law married, first of all, you have to have the capacity to be married, which means you have to be of a sufficient age, you have to be not married already, because that's a problem. You have to have a present agreement to be married. You have to have some public recognition of the marriage. That greeting card that she had wasn't enough. Now, often what we see in common law marriages is people file joint taxes together. They claim their spouse on an insurance policy, health insurance. There's some public recognition that they held them out to be husband and wife other than just that they were lazy at birthday time. I want you to notice what's missing from the elements of common law marriage. What's missing from those elements is a time requirement. There is no time requirement. You can be shacked up for one night, and if you have those other elements, the capacity and the agreement and the public recognition, then you're hitched. The good news for divorce lawyers is that if you're common law married, that may also mean that you need a common law divorce, and that just expands our client base. So you have to get divorced just like you would if you had gone to a preacher. The third myth that I hear a lot is that a mother in the state of Alabama has a much better chance of getting custody of a child. I'll tell you, that's changed probably more than anything in my 25 years of practice, and I think Alan will bear me out on this. Once upon a time, there was what we called the tender years presumption, and that said that if you had a small child, that child was better off with mama. But ladies, when we asked for our equal rights, they gave them to us, and part of what happened in 1979 was they took away that presumption and said, we no longer can say that by law the mother is the better parent. Dads have equal rights, and dads are active participants in their child's lives, and they have an equal footing to custody. So when we go into court now, it doesn't matter whether I represent daddy or I represent mama, they stand on equal footing with that judge. There are factors that our courts tell our judges that they have to look at when they have to make that really important decision about custody. Those include the age of the child, the age of the parents, the character of the parents who are seeking custody, the relationship of the child and the parent, the conduct of the parties, the sex and the age of the children, and the parent's ability to care for the child. Now, often, I'll pick on my male clients now because it's usually them, often I will have a husband come in. He's been married to a woman who has been a stay-at-home mama for that child's entire life, and she stepped out on the marriage. And he will say, she's committing adultery, I should get custody. Well, conduct is one thing that the courts look at, but our courts say that it's not enough that there's adultery in a marriage when it comes to custody. You have to show that that adultery affected the child, that she left the child while she went out to be with her lover, or that she somehow neglected the child or her duties, or somehow the child was impacted, and that's really hard to show. So generally, adultery is not one of the factors that we look at in custody. There are three kinds of custody in the state of Alabama. There's sole physical and sole legal custody, which is pretty self-explanatory. One parent has the child primarily. The other parent exercises visitation and pays child support. The second kind of custody is called joint legal and sole physical. That means that the parents have equal say-so in raising the child in the big decisions, but that the child primarily lives with one parent. The other parent has visitation. When you have the joint legal sole physical custody, the parent who has the sole physical custody is supposed to consult with mom or dad. But in the end, if the parent wanting custody wants that child raised Catholic, and the parent who doesn't have sole physical custody wants that child raised Buddhist, the child is going to be raised Catholic. The person with sole physical custody holds the trump card. The third kind of custody is joint legal and joint physical. And that's when both parents have the child roughly half the time. It doesn't necessarily have to be half, but portions of the time. We have people that do week on, week off, Monday, Tuesday with mom, Wednesday, Thursday with dad, alternate weekends. You may not be aware, but in Alabama, right now, there is a presumption that joint custody is favored. It is the policy of this state to show that children have, or to maintain a good relationship with both parents. And so, under our law, it's almost presumed that they be joint custody be considered before any other model is done. In the last few years, we have seen an explosion of true joint legal, joint physical custody. It's happening all the time, and especially here in Madison County. I have some of my own opinions about that, but it's up to the judges here, and they seem to be very pro. We've had legislation in Alabama that has not yet passed, but where they want the legislatures to rule that unless you can show that a parent is unfit, they should have joint custody. I mean, that should be the norm in the state of Alabama. It has not yet passed, but now I can tell you that in any of the custody models, if there's visitation awarded, especially here in Madison County, our judges have sort of a standard visitation schedule, and it's a very generous schedule. In Madison County, a person who's exercising visitation of his or her child gets his child on Wednesday night after school until Thursday morning. He or she gets their child the first and third and every other fifth weekend from Friday to Monday morning, so Friday, Saturday, Sunday night, that child's with the visiting parent. Half of the summer, holidays. I hope none of you are engineers, but I had a geeky engineer client who took a pen to paper and he figured out that under our standard visitation schedule, a non-custodial parent has the child 46% of the time. And that's not with joint custody. That's just with regular visitation. So our courts have already taken the steps to make sure that children have that meaningful access to both parents that is dictated by our statute. Also, in all divorce cases here in Madison County, our judges enter what they call standard parenting clauses. They are non-negotiable, folks. I have a lot of people who want to tweak them, and we don't have that power. That's one of the things that has to be entered in a divorce in Madison County. And those standard parenting clauses were developed by our judges to govern the conduct of the parties after a divorce with regard to their children. They say things like both parents have to consult with each other about decisions regarding the child. That the parent who doesn't have custody can go eat lunch with Junior at school if he or she wants to on a routine basis. That the party who has custody has to let the mom or dad know about teacher conferences and doctor's appointments, and that that parent has to have an opportunity to attend even though he or she may not have custody. The one that we see the most controversy over, and the one that people seem to want to strike out, is the shack-up clause. Our standard parenting clauses say that you cannot have a member of the opposite sex in the home where the child is present if you are romantically involved with that person. If you do, you are in contempt of a court order and you are subject, as we'll talk later, to some sanctions, including jail time. Often, people who have been divorced and have a live-in girlfriend will come to me, and suddenly this has become an issue. I can't tell you how many people I have sent over to the courthouse to get married to get around that provision, or they have to break up. But it's how it is right now. You cannot have somebody staying in your house unless you are married to them if you have a romantic relationship and the child is there. If I had one question that comes up more than any, this is the next one that I'm going to talk about. I often have clients come in and they say, well, what age does my child have to be before he or she can decide where they want to live? The answer is 19. And let me tell you why. At 19, that child can go live wherever he wants. But until then, the judge makes the custody decision. Now, a child's wishes are one factor that the court can consider in making a custody determination. But that's just one factor. And those other factors that I read to you about the character of the parent and the relationship, I submit to you that those are much more overriding. I can get a 12-year-old, folks, to tell me anything. Offer him a trip to Disney or a pony, and you're not going to get some really true feelings from that child. So our judges, I think, are aware of that, and I don't think that, first of all, my policy is to never put a child on the stand if I can avoid it. There has to be some really egregious facts before I will make a child come to court and talk about his mama and his daddy in front of a judge and some strangers like me. I just won't do it. But in those areas where I've seen it done, you know, the child is not the most credible witness generally, and even if he or she is, it's almost tantamount to child abuse to me to make that child put that decision in their hands. And our judges will do it too. The flip side of that is visitation. I often have clients who say, well, I know that my ex-husband's supposed to have visitation, but I can't make Junior go. Well, you have a visitation order. That order was signed by the judge. That order says that every Wednesday night, Junior is supposed to be with his daddy at his house. And if you can't make your child go to visit with daddy, well, can you make him go to school? Can you make him eat Brussels sprouts? Can you make him go to bed at night? I think that reflects on your character as a custodial parent if you can't, and our judges will take a very dim view of someone who tries to interfere with visitation that they've ordered. The next area that I want to go into is child support. I have many clients who come in and say, well, I'm willing to pay $300 a month and let her have custody, and that'll be my child support obligation. Doesn't work that way. Child support is not negotiable in the state of Alabama. Our courts, our Supreme Court, has issued a rule. It's called Rule 32, and it's well known among the divorce lawyers. Rule 32 tells us how to calculate child support. And we, as divorce attorneys, and you as parties, have to certify to the court that we followed the formula that they told us to follow. And it makes a lot of sense. I often have clients, many times a female, she may have been in an abusive situation, or she may just really have had enough, and her husband has agreed to give her custody, and she'll say, well, I don't want any child support. He'll give me custody if I don't ask for him to pay anything. Well, folks, child support's not for that mama. That child support's for the child. And a mama can't waive the right to child support. That's for the child, and that's what the courts are going to order. So that's kind of a red flag when I hear that being brought up. That tells me that there may be deeper problems in the relationship. In Alabama, when we have to calculate child support, we have to take a party's gross income. That's before Uncle Sam ever gets his first cut, before taxes are taken out. I often have clients who come in and say, well, you know, I've been getting overtime, and that's a lot of my check, but I'm not going to get overtime anymore now that I have to pay child support. It doesn't work like that. If you've routinely been getting overtime, that gets counted as well. I have soldiers, especially in this area, many soldiers who get BAH and BAQ. Our law says that we have to count income from any source. So if the government is giving you money for housing on a monthly basis, that counts as income. If your mama routinely puts $500 in your account so that you can buy gas every month, that gets counted as income. It's a very, very broad definition. It doesn't matter in Alabama if you have a high mortgage or car loans or credit cards and you're getting stuck with all that. And I often have clients who come in and say, well, I just can't afford child support. Look at my budget. Under Alabama law, that's not a consideration. We don't look at what the other expenses that you have are. We look at your gross income. We do the formula that the court gives us, and you have to pay that amount unless you've got some compelling reason not to. The child comes first. The mortgage and the car loan and your beer run on Saturday night is second to what your child needs, and that's how the court is going to look at it. What we do in calculating child support is to take the mama's income, the daddy's income, we apply it to the chart that the courts give to us, we add in daycare and health insurance, and then the party who is having to pay child support pays whatever percentage that is awarded. There's not a lot of wiggle room. In joint custody situations, and as I've told you recently, that's become more of a norm to us, I often have clients who come in and say, well, we want joint custody. And sometimes that's code for, well, I don't want to pay child support, so I'll say that I'm going to have custody of my child. If you have a party that's making $100,000 a year and you have a party who's making minimum wage, even when joint custody is awarded, the judge is still likely to order the party who makes more income to pay child support. So that's an error when people say, well, we're going to do joint custody and we'll just each take care of the child. That's not really fair. If a party's not making as much money, they can't take care of the child as well as the party who is earning more. And so our courts will compensate for that through child support. Yes?
What happens if the ex-husband moves to a different state?
Okay.
Like, I remember receiving $65 a month for 2 small children.
Okay.
And I could not get my ex-husband to pay more. He had moved to Texas.
Okay.
And
The question was, what happens when your former spouse moves to a different state and they have a child support obligation? We have what we call the Uniform Enforcement of Support Act, UIFSA. That is a law that all of the states have adopted. So it's been at least 10 years, probably before that.
it was before that.
Okay. Under the UIFSA, we have DHR workers that can collect, that they can go to other states. We have, DHR has a right to intercept tax returns. if a party owes a child support arrearage, there are enforcement mechanisms that we now have to try to get around deadbeat moms and deadbeat dads. And so I don't think we see that as often as unfortunately you must have, but there are enforcement provisions out there. Yes, sir.
Is there an advantage to being the one that files or being the plaintiff?
Question is there an advantage to being a plaintiff? And I will say unequivocally yes, for this reason. If you cannot resolve your case, and I will say that most divorce cases resolve, sometimes on the courthouse steps, but if you cannot resolve your case and you have to go to court, if you are the plaintiff, then you get to call the order of the trial. You get to go first. In my practice, even though I've been doing this 25 years, I am old school. I still write out an outline of my questions. I take my client up and try to put them in the courtroom before we have a trial so that they can kind of feel what it's going to be like. That judge that's hearing your divorce case, he may be taking a 20-year marriage and compiling it into 2 hours of time that he or she has to give to you. So it's really important when you're trying a case to be prepared, that my client be at ease, that he or she be able to tell their story. If I go first and I'm the plaintiff, then I can predict the questions, I can predict what order the witnesses are going to be called in, and I can almost rehearse with you what your testimony is going to be so that you can have a better presence and give the judge a better feel for your case. If I am the defendant, then the other side can call you to court first, can call you to the stand, they can ask you questions, I have to kind of do cleanup. We don't have that same rapport. So yes, I will say that if I have a client who feels like a divorce is imminent, I try to beat them to the courthouse door and file those papers first, just for that fact. Other than that, no. I don't think the judge cares whether or not you're the one that filed or the other person. You can make somebody so miserable that they don't have any choice to file, so the fact that you're the plaintiff I don't think really helps you. But it just for strategy, in my mind it does, and so I will, I'll try and encourage my clients to try to resolve things and to work it out. But if it looks like it's inevitable that we're going to be going to a court, I like to be the person.
What percentage of divorces actually go to trial?
The question was what percentage of divorces actually go to trial? That's a hard one. We have mediators, and in fact I am a mediator, so there's often times when we try to settle the case and judges will send the both parties to a mediator to try to settle it first. I think the most difficult issues to settle are obviously child custody. It's hard to divide the baby in two, although the joint custody statutes have sort of done that for us. And the second one is alimony. That's one of the issues that really seems to get into people's crawl. But I would say in my practice, by and large, I would say more cases settle than not. It just really depends on getting your client educated, getting through the process, and hoping that the other side is reasonable so that, the best settlement is when everybody's unhappy. So that's what we kind of shoot for. All right. The next myth that I often hear is that child support obligation ends at age 18. That is not true. Alabama is rare among states. Our age of majority is 19. You have a duty to support your child until he or she is 19 years old. Now, until October 4th of last year, you also could have an obligation to pay college support for your child. We were one of 7 states that recognized a parent's duty to pay college support. For 24 years, virtually the whole time that I have practiced, that has been the law. And for 24 years, I argued that that was not a constitutional law. And finally, the Alabama Supreme Court agreed with me. Last October, they issued a case, and actually it came right out of here in Limestone County. And the Alabama Supreme Court reversed those 24 years of jurisprudence and said, no, you can't make a parent pay for a child who's over the age of 19. It has really turned our family law on its ear. That has not been what we've done. We have worked toward having a child supported through college and put restrictions on it. They had to make a C average and they had to be full-time. And now there's no more of that. Now the decision, the ex parte Christopher case is the one that came out in October, and it made the news. It was a big deal. The Christopher case said that if you already have a support obligation to pay college support, that it's not going to hold that unconstitutional. It's just for all the cases from this point forward. So if you know someone who was already paying for college or who put it in their papers when the child was young, then he or she may still have to pay it. But from this point forward, you do not have a duty to pay college support. And it makes a lot of sense to me. You know, if you're married, you shouldn't be treated differently than if you're divorced. If you're married, you don't have an obligation to pay for college. I don't think you should if you're divorced, but that's what the court has now said. Now, in that same vein, there is also a duty to pay for disabled children. If you have a child that could not become self-supporting, right now, under the current law, you may have a duty to support that child past the age of 19. But the law to support disabled children was the same law that was used to pay college support. The court has knocked it down with regard to college. I think it is likely that they are going to knock it down for disabled children. So I think if someone challenges that in the Supreme Court, you're no longer going to see that duty. But as we stand here today, if you have a disabled child, he or she may have a right to support beyond the age of 19. Yes, ma'am.
Yes, my question is, if you have a deadbeat dad and your child's like 19 when you start receiving child support, in addition to that, you finally get the money, but it's drawing interest, it's accumulated interest over the years. Then you get this nice little 1029 thing in the mail saying you got to pay Uncle Sam for the interest that you received.
Okay, the question is about getting interest on child support?
Yeah, you get interest and then you have to pay taxes on it. I want to know, that doesn't seem very fair to me.
I wasn't even aware that there was.
Oh,
I had no idea. From Alabama?
Yeah.
Yeah. Child support judgment becomes due at the time that it's ordered. And they changed our statute. It used to run at 12% interest. They changed it about 2 years ago. It only runs at 7.5% interest now.
Well, from the date the judge ordered he paid to my child turned 19, it was quite an accumulation.
I bet.
And so then after I got my 1029 form, I'm like, what's this? And they said, well, you get to pay Uncle Sam as of 3 years ago.
Generally, child support is not income for your tax purposes. Alimony is, child support is not. But what this lady is saying is that the tax code does tax the interest on child support, and I honestly was not aware of that. That's something new to me.
Well, it exists.
All right. While we're on the subject of alimony, that's kind of a dirty word in the divorce practice. Nobody wants to pay alimony. What you need to understand about alimony is that it is a reality in this state. I just described to you in child support situations how we calculate child support. We do that nice little formula. There is no such formula in an alimony case. If I have a client walk in and he or she has been in the workforce and the spouse has not, I can't do a nice, neat calculation like I can for their children and say this is what you're going to owe. Alimony is purely discretionary with the court. Again, like child support and child custody, the court's going to look at some factors that have to be considered, and some of those include the earning capacity of the spouse, what their education is, what their health is. You have to understand in divorce law, we sort of have two different components when it comes to dividing the marital assets into allocating income. We have a division of assets. That's kind of the pie. That's the house and the cars and the retirement accounts. That's the stuff that we can identify to be marital assets. And then we divide up that pie between the two parties. Alimony is designed to compensate one of the parties, and I'll say generally it's usually the wife who's been the non-working party. It's designed to allow that spouse to continue in the same lifestyle to which he or she was accustomed during the marriage. It doesn't matter how much property they get. That's sort of like to compensate for income that may be generated. Now, alimony is terminable if a spouse is receiving alimony and she or he gets married or they cohabitate with a member of the opposite sex. That alimony obligation stops. So I advise my clients, when they have divorced and they're receiving alimony and they think that they have met Mr. Wonderful, he better be really wonderful if it's worth losing that alimony that I fought so hard for them to get. Now, alimony is modifiable, so if you have a husband who's paying alimony to his former wife, and he loses his job or he's had some kind of a medical problem and he can no longer earn the same income that he was earning when he was ordered to pay that alimony, he can ask for it to be decreased. Similarly, if you have a spouse who's receiving alimony and he or she has had a change in their circumstances, that they now need more alimony or they need it for longer, then he or she can also ask to have that adjusted. So that's one of those cases when we can see our clients again, even after we've had a final judgment of divorce. In fact, there was a case, as Alan told you, I read every case every week. I am full of useless knowledge and I am an absolute bore at cocktail parties. But last Friday, there was a case here in Madison County that the spouses had divorced in 1990. The wife agreed that she would receive $500 a month in alimony. She worked as a receptionist at some kind of a business. 20-some years later, she comes back and she says, I'm 72 years old now. I don't have any computer skills. All I've got is a little bit of Social Security and this tiny bit of alimony. And oh, by the way, the husband was like Midas. He had gotten some property as part of the divorce and had accumulated it into like $1.5 million. He had a retirement from the government that she wasn't able to touch in the divorce. So he was making, I think, $80,000 a year. She was making $12,000. And she went back to the court and said, hey, hold on, I need more alimony, after 20-some years. Our trial judge here said, no, I don't think that you've shown a material change in circumstance. And they appealed that decision. In Alabama, if you go to our trial courts and you get a bad result or you get a result you don't like, you do have a right to go down to Montgomery to our courts of civil appeals in domestic cases and ask them to take a look at it. There's 5 judges on that court of civil appeals that read the transcript that the judge had and make a determination about whether that was fair. The court of civil appeals said that the trial judge made the right decision, which was surprising to me, frankly, based on what I saw in the decision. I was not part of the case. But of those 5 judges, 3 of them ruled in favor of the husband and 2 ruled in favor of the wife. So they now have a right to take it to the Supreme Court. And I did talk to one of the attorneys earlier today, and they are pursuing that, so we'll see. But even after 20-some years, this man's been paying $500 a month in alimony. He thinks he's on easy street. In comes wife and says, no, I want more. So stay tuned, and maybe next year I'll be able to tell you how that works out. Yes, the question is child support modifiable because someone loses their job? I will tell you, that's probably the most repeat customer that I have. There are always changes in child support. You know, you add in daycare. A daycare for a 2-year-old is a lot different than a daycare for a 7-year-old. And then, of course, when they become 12 or 13, there's no daycare. I generally, if I have clients who come in to see me when the child is very young, I may see those clients 2 or 3 or 4 more times between then and when that child reaches the age of 19. It's just one of those things that has to be recalculated. The other thing that we have is when we do a child support calculation, it's front-loaded into that chart. So you may have to pay $1,500 a month for 2 children. So often when the oldest child turns 19, husband or wife will say, well, I'm just going to cut that child support in half now, because there's only 1 child. Well, that's not how it works. You have to come back in and get that recalculated, because under our scale, you pay more for 1 child than you do 2. You just can't automatically cut it in half. And until the judge says that you don't have to pay $1,500 a month, you better pay $1,500 a month. Yes, sir?
Have you noticed any bias with the alimony? I mean, do you see many cases where the man receives the alimony?
The question is, do I see cases where men receive alimony? I see them all the time in Madison County. You know, we have such a good per capita income. We have so many successful females. And, yep, that's what women's rights did to us. Boy, howdy. Yes, I do see it all the time. It's a little less common still because generally we have, you know, usually the homemaker and the husband. There's not that many house dads. But when we've had them, they got to pay. All right.
Joan-Marie, would you touch on what is the effect of putting property in, let's say, the wife's name or the husband's name, and what a true effect that it has?
Okay. The question is about people's separate estates. When you have property that's in joint names or you have property that's in individual names. The law in Alabama is If property is used for the common benefit of the parties, it becomes a marital asset. Now, I often have people come in and say, well, we've lived in this house for 20 years, but it's only in my husband's name, so I guess I'm just not entitled to any of it. Wrong. That property was used as the marital residence. The wife certainly benefited from it. So even though it's only in the husband's name, it becomes a marital asset. Similarly, retirement accounts. Generally, one party or the other has a substantial retirement account, and that's usually a very large asset of the marriage. We have a separate statute that deals specifically with retirement accounts. It's kind of controversial. It's different than other states do. But under Alabama law, if you have been married for 10 years while that retirement has been accumulated, then your spouse has a right to up to 50% of that retirement account. Even though that's only in the husband's name or only in the wife's name, that 10 years gives you a right to it. Now, there's a lot of family law lawyers that say, well, 10 years is arbitrary. You should have that right after 1 year. But right now, that's what the statute says. Now, we have those cases where a party inherits money or a parent gives a party money. If you hold that account in a separate account and you never touch it so that it benefits the marriage, then you can hold on to that money as your separate estate. But frankly, folks, I see that very seldom. There are cases where you may have an account, you make a mortgage payment out of it, and that mortgage is on your joint mortgage. Well, guess what? Now your spouse has benefited from that asset that was in your separate name, and that can convert it into a marital asset. So when I have clients who come in and they have those separate estate issues, if they have a trust or they have an inheritance account, we really have to educate them about how it is to keep those monies separate, because in Alabama that can be done. Now, last year there was a case where a woman had an inheritance account. She bought the party's son a tuba from her account, and the husband said, that's all she had bought was a tuba. And the husband said, well, look, that was for the benefit of both of us, so that's now, that account should all come in because we bought that tuba. The Court of Civil Appeals said no, that wasn't true. So the moral of that story is that the wife didn't blow it by buying a tuba. Sorry. Okay. Yes, ma'am.
If a wife comes in, for instance, and says, I don't want to be married anymore, and there's no reason, just don't want to be married anymore, why would she be entitled to alimony if she just wants out of marriage?
Okay. The question is, if the wife's just had enough and she doesn't have a really good reason, why should she be entitled to alimony? Unfortunately, that's not one of the factors. What they look at is how long she's been married, if she had separate income during the marriage, what her earning capacity is in the future. If she has sat on the front porch and eaten bonbons for the whole marriage, she may still have an entitlement to alimony. There was a case recently that I saw where the wife had some sort of disability, although it looked like she still had some income coming in. She never did the dishes, she never cleaned up, she didn't help with the child. She really just sort of mooched off the husband. The trial court did not give her alimony, and on appeal, the Court of Civil Appeals said that that was okay. And that surprised me, frankly, because it had been a long-term marriage. The biggest factor that I see in an alimony award is the length of the marriage. And when a court awards alimony, they can award different kinds. They can say, well, I'm going to award alimony for 10 years. We're going to call it rehabilitative alimony. So that gives her time to get back to school, to get a degree, to get back in the workforce. Or they can award permanent alimony, where they say, you got to pay alimony until she remarries or cohabitates or dies, whichever one comes first. And generally, the paying spouse really hopes for a quick death, but that can help.
If the spouse leaves and heads to another state and calls back here to Alabama and says, I want a divorce, what state laws apply?
All right. That's a jurisdictional question which can get complicated, but generally, if you have to have subject matter jurisdiction over the party. So if your wife goes to another state and asks for a divorce, and the husband has no contact with that state whatsoever, that state cannot exercise jurisdiction over him. So the only place that they could get divorced would be where the husband is, which would be here. But that does get into some really complicated issues. But generally, that's how it works, is if you have to have some minimum contacts with that state that would sort of put you on notice that you would be held up, okay?
Joan-Marie, I would like to-